I'm Maisie from HPC, and in this video I will provide an update about Martyn's Law reaching Royal Assent and what this means from a health and safety perspective. The Terrorism, Protection of Premises Act 2025, commonly known as Martyn's Law, reached Royal Assent on Thursday the 3rd of April. The intention of Martyn's Law is to prevent and reduce harm of terror attacks at premises and event venues by improving security and preparedness across the UK. To reduce vulnerability to acts of terrorism, premises and events will need to take steps to prepare for potential terrorist attacks, as well as know how to keep people safe should an attack occur. This will require premises and venues to fulfil different requirements depending on how many individuals they expect to be present. Martyn was one of the 22 people sadly killed in the Manchester Arena bombing in 2017. Martyn's mother started and led the campaign for this new law in 2019. The reasoning behind this campaign was to ensure that public places become better prepared for terrorist attacks in order to reduce the risk of physical harm and impact. Royal Assent is the last requirement needed before a parliamentary bill becomes law. The bill received Royal Assent on the 3rd of April 2025 from King Charles, providing formal approval for it to become an Act of Parliament. Whilst Martyn's Law reached Royal Assent earlier this month and the law is formally in place, the provisions will not come into force for a couple of years. However, there will be an implementation period of at least 24 months. This period will allow those responsible for premises and events sufficient time to understand their new obligations under this law and take action accordingly. There will be a tiered approach concerning the requirements of certain premises and events, and this will be based on the number of people reasonably expected to be present simultaneously at a premises or event. The first tier is standard tier, and this includes premises and event venues with a capacity of 200 to 799 present individuals, including staff. The requirements are a lot simpler for this tier, with no requirements to have physical measures in place. They are typically low-cost activities designed to ensure those working at premises and events are better able to reduce the harm and save lives in the event of attack. Some of these activities may include undergoing evacuation training, locking doors, closing shutters, and identifying safe routes to cover in the event of an attack. The Home Office states that persons responsible for standard tier premises should notify the Security Industry Authority, the SIA, that they are responsible for their premises and have in place, so far as reasonably practicable, appropriate public protection procedures that could be reasonably expected to reduce the risk of physical harm being caused to individuals. The other tier is known as enhanced tier, which is premises with a capacity of more than 800 people, including staff, and qualifying public events. They will have the same requirements mentioned in the standard tier. In addition, they must also, so far as is reasonably practicable, put in place suitable public protection measures to minimise their vulnerability to terrorism and the risk of physical harm if an attack was to occur. Some of these protection measures may include bag search policies, CCTV, and monitoring and vehicle checks. The Home Office states that persons responsible for enhanced tier premises and qualifying events will be required to notify the SIA that they are responsible for the premises or event, have in place, so far as is reasonably practicable, appropriate public protection procedures that could be expected to reduce the risk of physical harm being caused to individuals, have in place, so far as reasonably practicable, appropriate measures that would be reasonably expected to reduce both the vulnerability of the premises or event to an attack of terrorism occurring, and the risk of physical harm being caused to individuals if an attack was to occur there or nearby. They must also document the public protection procedures and measures in place or proposed to be in place and provide this document to the SIA. Where the responsible person is not a specific individual, they must designate a senior individual with responsibility for ensuring that the responsible person complies with these requirements. The businesses to which this new legislation will apply have no requirement to comply until the legislation comes into force after the implementation period. However, some may choose to begin implementing measures in readiness for this to become law. The Home Office are expected to publish statutory guidance during the 24-month implementation period to help those responsible understand their responsibilities. Clear guidance will be provided to duty holders to ensure all parties understand their responsibilities and how to fulfil them. The guidance is intended to be straightforward, requiring no specialist knowledge. A dedicated regulator will be established to support the law's enforcement, offering advice, support and direction to those responsible for managing premises and events. It is really important to be aware of this update and, if relevant to your business, begin to consider how you can prepare for this change. Having this update on your radar and implementing changes will not only improve the safety of your premises or venues, but also ensure compliance in the future when this becomes law. If you require any further information or guidance, please do not hesitate to get in touch. The team at HPC can help your business prepare for this new legislation in several ways. We can offer support by creating risk assessments relating to the above, ensuring company policies reflect the new changes in legislation, as well as act as your company's competent person for health and safety.